Welcome to Perspectives, Fasken's legal voices on business.
Hi everyone, my name is Tshepo Mokwana, an associate at Fasken, and today I'm joined by pension law partner and colleague Rosemary Hunter. Hi Rose.
Hi Tshepo, and hi to all our listeners.
In this podcast, we'll talk about a very interesting judgment handed down by the Constitutional Court on 14 March 2022, and that is the Municipal Employees Pension Fund and another versus Mongwaketsi and another. It's very interesting for the precedence that it gives to the pension law industry. So to just jump right into it, the facts of the matter are that the Ngakamodiri Molema District Municipality employed Dineo Mongwaketsi as its chief audit executive on a 5-year fixed-term contract. When her employment commenced in February 2012, she and the municipality together completed an application form for her membership of the Municipal Employees Pension Fund. At that time, no one told her that in terms of the rules of the fund, only permanently employed municipal employees could become members. So the municipality deducted both member and employer contributions from Ms. Mongwaketsi's monthly remuneration and then paid them to the fund. She was then subsequently treated as a member. 2 years later, Ms. Mongwaketsi discovered that she had never been eligible for membership of the fund in terms of its rules. So the municipality, being her employer, stopped deducting and paying contributions to the fund and then asked the fund to refund her all the contributions she had then paid to that date, approximately 850,000 with interest. The fund refused that request, saying that she had indeed become a member and enjoyed all membership benefits, including death and disability cover. Her contract then expired 2.5 years later, and the standoff with the fund had not been resolved. The fund then paid her an early withdrawal benefit based only on her member contributions and from which tax had been deducted. She was naturally aggrieved by this and so lodged a complaint against the fund with the pension fund's adjudicator. In it, she asked the adjudicator to order the fund to pay her the balance of her contributions plus interest. After considering the submissions of both parties, the adjudicator granted the order Ms. Mongwaketsi has sought, but dissatisfied by that, the fund then applied to the High Court in terms of PAJA, or the Promotion of Administrative Justice Act, for an order reviewing and setting aside the determination of the pension fund's adjudicator and its order. At the same time, they appealed the adjudicator's findings in terms of Section 30P of the Pension Funds Act. And from there, that's where things got interesting. So that's where I'd like you, Rose, to explain to our listeners as to why.
Thank you, Tshepo. That's a good summary. As you said, this case did get interesting. In fact, it got so interesting that it ended up in the Constitutional Court. So let me walk you through the steps of how it got there and what the final outcome was. The High Court agreed with the adjudicator and found in favour of Ms. Mongwaketsi, but the fund was unhappy with this, so it appealed against the High Court's rulings to the Supreme Court of Appeal. Unfortunately, Ms. Mongwaketsi, being an individual, could not afford to appoint lawyers to defend the findings of the adjudicator in the High Court, and so she was not represented at the hearing before the Supreme Court of Appeal. So the Judge President of the Supreme Court, Justice Meyer, asked the Bloemfontein Bar to appoint one of its members, one of the advocates, to present arguments as an amicus or friend of the court, so that the court wouldn't hear arguments only from one side. So after hearing the two sets of arguments, the Supreme Court of Appeal, like the High Court and like the adjudicator, ruled in favour of Ms. Mongwaketsi and against the fund. But then the fund successfully sought leave to appeal to the Constitutional Court. Now, I had been very impressed by the judgment of Justice Malcolm Wallace for the majority of the Supreme Court bench, because he's such a teacher in the way that he writes his judgments, and he helpfully addressed and clarified many issues of relevance to retirement funds generally. So I was a bit concerned that when I heard that this matter was going to the Constitutional Court, I was concerned particularly because if Ms. Mongwaketsi had not been able to afford representation in the Supreme Court of Appeal, it was likely she wouldn't be able to be represented before the Constitutional Court. So I brought this to the attention. I contacted the Centre for Applied Legal Studies at the University of the Witwatersrand, WITS, because I was aware that CALS had a special interest in human rights issues relating to retirement funds. So I told them that about the main issues, legal issues that were important not just to Ms. Mongwaketsi but to retirement funds generally. And I asked if it would be willing to apply for leave to intervene as an amicus. Fortunately, it was, and Advocate Sandile Khumalo is a senior counsel and one of our leading pension law specialists at the bar. He agreed to act on behalf of Carl's pro bono. And as expected, Ms. Mongoketse was not represented at the hearing, and I think that the Constitutional Court derived considerable benefit from the submissions made by Advocate Khumalo on behalf of Carl's during the hearing, which took place in November last year.
Yeah, so Rose, what were then the big issues that the courts, from the High Court until the Constitutional Court, had to deal with in this matter?
Sure. As in most litigation, there were skirmishes between the parties on a wide range of issues, but I want to deal with only three, and then only with what the Constitutional Court had to say about them, even though I thought the Supreme Court of Appeal Court judgment, the majority judgment, was particularly good. These issues might seem a bit technical, but as I said, they're very important for the retirement industry as a whole, and those who are, I think, legal advisors, trustees, and others who are deeply involved in it would understand why they're important. So the first issue was about membership of a fund and whether Ms. Mongoketse had become a member of the fund because she had applied for membership and had been paying contributions for 2 years and so on. The fund's argument was that Ms. Mongoketse became a member of the fund, even if its rules had disqualified her from membership, because there was a rule that said that the board could decide whether somebody met the eligibility criteria or not. The second argument of the fund was that Ms. Mongoketse was stopped from arguing that she had not become a member because she had made a representation that she was a member by paying contributions to the fund. And so she had represented to the fund that she was entitled to be a member, and she was either stopped from arguing that she was not, or she'd waived her right to argue that she was not. Now, just a side note, estoppel is a formal legal term. A person may be stopped from asserting a right or raising a defense to a claim that is inconsistent with their own prior conduct, provided that the claim itself is not based on invalid conduct. Justice Rogers, on behalf of the unanimous bench of the Constitutional Court, rejected both of these arguments by the fund. He reaffirmed that, 1, the rules of a fund are binding on it in terms of Section 13 of the Pension Funds Act, and 2, conduct that is not authorized by the rules of the fund is ultra vires, so it's beyond the powers of the fund, and accordingly invalid. He also confirmed that the principle of estoppel can't be used to make what is invalid valid. So the second issue was whether the pension fund's adjudicator had jurisdiction to determine the dispute. Not surprisingly, the fund argued that if Ms. Mongoketse had never become a member of the fund, then the adjudicator did not have jurisdiction to determine the dispute because Ms. Mongoketse could not fall within the definition of complainant as defined in the Pension Funds Act. And Section 1 of the Pension Funds Act defines any person who is or claims to be a member of or former member of a fund, a beneficiary or former beneficiary of a fund, an employer that participates in a fund, a spouse or former spouse of a member or former member of a fund, any group of people who of that kind, the board of a fund, and any person who has an interest in a complaint.
Yeah.
So this was an argument that found favor with 2 of the 5 judges in the Supreme Court of Appeal. They said she wasn't a member or former member and she wasn't any of the others, and you couldn't just have an interest in a complaint if there wasn't somebody else who had raised the complaint in the first place. But before the Constitutional Court, Advocate Khumalo on behalf of Carls argued that the interpretation of the Act should be done with due regard to the constitutional rights at stake, including the right to Social Security, basically arguing that retirement funds are vehicles for delivery of Social Security benefits. And that's a right under Section 27 of the Bill of Rights. It also should be taken into account as the right to have legal disputes decided in a fair public hearing in terms of Section 34 of the Bill of Rights. So Advocate Khumalo pointed out that if the adjudicator could not entertain complaints from people who are improperly admitted to membership, their only recourse would be to litigate in the High Court, which most would not be able to afford to do. So while Carls agreed that Ms. Mongoketse did not fall within the scope of A to C of the definition, that's the member, former member, beneficiary, former beneficiary, and so on, it argued she did fall within the scope of paragraph D because she had an interest in a complaint as defined. The fund, on the other hand, said that the term complaint is defined as a complaint of a complainant. So you can't have a complaint without a complainant. And that was a very literal reading of it. But the Constitutional Court chose to adopt a wide interpretation of paragraph D of the definition of complaint, saying a person who has an interest in a complaint should not be confined to a person who has an interest in an existing complaint by another person who was a member, former member, beneficiary, former beneficiary, and so on. So what limits the adjudicator's jurisdiction, the court said, was the definition of the term complaint, not complainant. And it found that the dispute concerning Ms. Mongoketse's demand for a refund of her contributions was in fact a complaint relating to the administration of the fund, and so the adjudicator did have jurisdiction to determine it. The third issue was, finally, a smaller issue but still important, was who was entitled to a refund of the contributions paid by the municipality to the fund for Ms. Mongoketse's benefit. Now, as you know, under the Pension Funds Act, it's the employer's responsibility to pay not only its own contributions, but if there are contributions to be paid in terms of the rules by the member, it is the employer's job to deduct those contributions from the member's salary and pay them to the fund. And the employer wasn't a party to this litigation. So what Ms. Mongoketse was claiming was a refund of her contributions plus interest on the basis that the fund had been unjustifiably enriched by those contributions because it had never been entitled to be paid them. And she had suffered a loss as a result of the unlawful, invalid payment of those contributions. One of the Supreme Court of Appeal judges had held that since it was the municipality that had been responsible for deducting and paying the contributions, it was the municipality that should have been claiming them back. Mm-hmm. But Justice Rogers of the Constitutional Court just disagreed with this, and he said, and I quote, "The municipality in law owed Ms. Mongoketse her full salary. She authorized the municipality to pay part of it to the MEPF, the fund in this case. If A owes money to B, and B instructs A to discharge the debt by paying the money to C in discharge of a debt which B mistakenly believes she owes to C, then it is B, Ms. Mongoketse in this case, and not A, the municipality, who can pursue the condictio indebiti against C, which is the fund." And that's a general principle of these kinds of claims.
Yeah. Well, it seems to me that the main lessons to be drawn from this judgment are threefold. One, that a fund has to be very careful about ensuring that it acts strictly within the limits of the powers given to it in terms of its rules. In particular, it must check whether each person who signs up for membership is in fact eligible for membership of the fund. And by the way, this was a lesson that all funds should have learned from the Brian Molefe and Eskom Pension and Provident Fund case. But secondly, based on this Concord ruling, the previous assumption of what is and what is not a complainant has been revised, specifically regarding who is entitled to take a grievance to the adjudicator. And thirdly, just because an employer has a duty in terms of Section 13A of the Pensions Funds Act to act as the conduit for the payment of contributions to an occupational retirement fund, that doesn't mean that any refunds payable by the fund in respect of a member must be paid to the employer. The true source of the contribution is the remuneration of the member, and by consequence, the member itself. I'm not sure, Rose, did I summarize the judgment nicely?
Yes, you did, Serpo. Just a couple of things. You mentioned that a retirement fund should have a proper procedure in place to try to minimize the risks that they sign up people who are not in fact eligible for membership, because It can be a big process. Now they have to pay to reverse all these transactions, disinvest money, work out what they owe the member, and so on. So certainly I think that a fund should devise a procedure for making sure that an employer certifies that a member falls within whatever the categories of eligible members, so that they would have to answer questions that they could be held accountable for, like, was the person employed in terms of a fixed-term contract? How long is that fixed-term contract? Or was that person employed in terms of a permanent contract of employment, and so on? All the eligibility criteria. But there's another angle that wasn't addressed at all in this case, but something that I think that employers should think about is the risks that they may take if they are signing people up for membership of a fund without checking that their employees are in fact entitled to be members of those funds. Because it's from the employers that most new employees expect their employers to know what their rights and obligations are in relation to employee benefits. And so I think that it's important that an employer also trains its HR staff, or makes sure that its HR staff are well versed in the rules of the various funds in which the employer might be participating, so that they know to advise the employees or to tell the employees that you must belong to this fund or you can't belong to that fund, and so on. And I think that's just one of a range of things that employers should be careful when they're onboarding new employees to address.
Yeah. And from what you've just said, I think perhaps the other thing is to review their membership forms, that it could be clear from the forms itself whether one is eligible for membership, and that possibly could have avoided something in a case like this.
Yeah, that's entirely right. And so I'm sure you would agree with me, Tsepo, that this case and the sort of surrounding issues show that pension law is constantly evolving and remains interesting and absorbing for people like me and you for a long time to come.
Indeed.
Thank you. It's been a pleasure to chat to you about the case today. Cheers.
Likewise, Rose. Goodbye. Thank you.